Debt is one of the most difficult circumstances that someone may endure. It can be even more unpleasant to deal with collection agencies or debt collectors. The constant phone calls and letters can have an overall negative impact on your overall mental health. However, even though you are facing major financial difficulties, there are still several options available to you. No matter what, don't give up hope. There are several steps you can take to lower your debt and stop the constant harassment. Welcome to the Seth Rain Money Guide, where we discuss ways to help make money work for you instead of you working for money. In this video, we are going to discuss ways you can deal with debt collectors when you don't have enough money to pay them. At the end of this presentation, you will know your rights as someone who is in debt and feel more confident when dealing with debt collectors. But before we get into it, please be sure to click the subscribe button. Also, don't forget to tap that bell button so you can get notified when we upload new content. There will be many videos covering a wide variety of financial topics in the future, and we don't want you to miss a thing. Also remember that we are not financial advisors, nor are we legal experts. Always consult with a professional financial advisor or attorney when trying to handle your particular financial or legal situation. With that said, let's get started. It is critical that you do not hesitate to deal with your creditors and debt collectors directly. Too often, the common response from people who are deep in debt is to go into hiding. They don't want to pick up the phone or check their mail. However, while you are hiding, the debt is still there, and the damage to your credit report is simply becoming much worse. But here is the reality of the situation. You actually have more alternatives and a better bargaining position than you realize. There's really not a whole lot a debt collector can do if the debt is unsecured. Knowing this puts you in a much stronger position of power. Now here are 3 things you need to know when dealing with debt collectors. Number 1. When it comes to standing up to your creditors, know your rights and the law. It can be quite unnerving knowing you have debts that you are unable to pay. Debt is stressful, especially when you start receiving letters and phone calls from your creditors on a regular basis. A collection agency is required to give information about the debt to you in writing within 5 days of their initial contact. This includes information regarding the nature of the debt as well as your right to dispute the debt. The notification should include the amount of the debt, the name of the original creditor, and information on how you can challenge the debt within 30 days. It's important to note that the 30-day mark begins when you receive the notification, not when the letter is mailed. If you believe the debt is in error, then you have 30 days to dispute the debt in writing. No further collection attempts or communication are allowed to occur until the debt has been verified in writing. Knowing your rights is the most effective strategy to combat debt collectors. There are laws that regulate what collection agencies and creditors are allowed to do. It is crucial to understand these laws. In the vast majority of situations, all of the most valuable guidelines are included in the Consumer Credit Protection Act, or CCPA. This act applies solely to secondary parties, including a collection agency. It does not apply to the original creditor. There are many limitations set by the CCPA that are helpful to debtors. Here are some of the most important limitations. It is illegal for a collection agency to threaten you with arrest for your debt. Put simply, you will not go to jail if you can't pay your debt, and it is illegal for a collection agency to threaten you with the prospect of going to jail. Phone calls from collection agencies are only permitted between the hours of 8 a.m. and 9 p.m. in your time zone. The collection agency is breaking the law if they call you outside of those permitted times. Be sure to keep a log of the phone calls and any other communication you receive from a collection agency. Always include the date, time, and the name of the caller. The collection agency is not permitted to use vulgar language or make unreasonable threats. Instances of inappropriate language would be swearing and racial slurs. Nearly anything beyond informing you that you risk further damaging your credit is considered an unreasonable threat. A collection agency is not permitted to contact your friends, family, employees, employer, or neighbors to discuss your debt. The collection agency can only deal directly with you regarding your debts. While they are allowed to contact others in order to establish your location or contact information, they are only allowed to approach a specific individual once. If they contact your employer, it can only be to verify your employment and nothing else. One of the most effective provisions of the CCPA is your right to issue a letter to the collection agency to terminate all communication from the collection agency regarding your debt. When you write your letter to the collection agency, identify yourself and the debt by including the original creditor's name and the account number. Mention the FDCPA, which is the part of the CCPA that establishes the guidelines for collection agencies, and inform the collection agency that you don't want to be contacted regarding the debt under any circumstances. All of this must be done in writing. Verbal communication is insufficient. The FDCPA is a powerful provision, and collection agencies violate its rules on a fairly regular basis. Any violations you encounter should be documented. It is actually possible to win a case against debt collectors which break those rules. Besides calling and writing to collect debt, collection agencies can also garnish up to 25% of your wages. However, the creditor must first file and win a lawsuit. For small debts, this hardly ever happens. The amount of time and exorbitant cost to file a lawsuit just isn't worth it in most cases. Number 2. Know what actions you can take when debt collectors break the law. Believe it or not, debt collectors violate the law when attempting to collect a debt quite often. Armed with the knowledge about what is and isn't permissible when it comes to debt collection, you can fight back when a collection agency breaks the law. Here are some steps you can take when debt collectors have violated the law. Document any illegal communication or behavior. Before you record a conversation with a debt collector without giving any notice ahead of time, make sure it is legal in your state. If possible, have someone else to serve as a witness on the phone with you. At the very least, when you are called by a creditor or debt collector, make a note of the date, time, and name of the caller. Take notes on the content of the call and precisely what was discussed. Submit a complaint to the Federal Trade Commission, or FTC. The FTC is the government body that regulates collection activities. The government makes it easy for you to file a complaint with the FTC. Check the description below for a link to the FTC website where you can submit your complaint. Send a copy of the complaint to the state-level agency that regulates debt collection. It can take some time to find the right agency in your state. Your state's official government website will have the information you need. Send a copy of the complaint to both the creditor and the collection agency. When a complaint is filed, it's not too unusual for the original creditor to cancel the debt due to liability concerns. The collection agency might also send the debt back to the original creditor. Sue the collection agency when they break the law. Each violation of the FDCPA results in a $1,000 fine. It is quite common for debtors to be awarded several $1,000s in the case of multiple violations. You could also recover any financial losses you may have suffered. This includes any medical or therapy costs or any other costs incurred as a result of stress and worry caused by unreasonable collection attempts. Remember that debt collectors are in the business of collecting money, not losing money. Any threat of a lawsuit received by a debt collector is cause for concern. Number 3. Know how to negotiate with debt collectors. It is completely possible to bargain with debt collectors about your debt. Most of the time, debt collectors are only compensated after the debt is collected. Typically, they are paid a portion of the total amount collected. Sometimes they purchase the debt from the original creditor. The vast majority of debts collected by debt collectors are unsecured debts. In the case of secured loans, such as loans used to buy an automobile, the original creditor would normally take legal steps to seize the asset. Remember, the debt collector wasn't the one that loaned you the money. The collection agency isn't actually concerned about how much you owe. Their only concern is quickly collecting as much money as possible. They want to minimize their costs. Calling and sending letters costs money. They have to pay people to write and send any mail communication, not to mention the postage fees, or to make all those phone calls. Collection agencies would much rather get a reasonable amount today than the full amount in 6 years. The debt collector doesn't really have a lot of power, and they haven't lost any money because you were unable to pay the original debt. They want to collect as much as possible on a debt, but will most often accept way less. Every collection agency will likely accept a reduced amount as payment in full. It's just a matter of how low they are willing to go. Each agency will have its own set of criteria. The more recent the debt, the more of the debt they will want you to pay. If a collection agency has pretty much given up on you ever paying, they might take as little as 20% of what you originally owed. For newer debts, expect to pay 75% or more. Some will be happy with 50%. The important thing is to stick with your number. They'll obviously try to talk you into paying more. Avoid agreeing to an amount you're unable to afford. If you decide to go with a payment plan, understand that you will most likely be required to pay the full amount. In most cases, debtors will only make a few payments and then stop. For this reason, there's not a lot of incentive for debt collectors to settle for less than the full amount. Also, be aware that when you go with a payment plan, they will ask for a list of your assets, income, expenses, employer information, and maybe even your banking information. If you're unable to make the payments, they'll have even more information than they did before. No matter what you do, never lie. You will have to sign documents under the penalty of perjury. While you likely will not be put in jail, if you ever do go to court, the court will not look too kindly on lying under the threat of perjury. Most importantly, remember that any agreement with a collection agency needs to be in writing. Do not make any verbal agreements. You're likely to get absolutely nothing out of the deal if it is not in writing. Debt collectors are intolerable and can make your life miserable. But remember the reality of the situation. Debt collectors would not be so demanding if they had the power to actually do something. They are masters of intimidation, but lack the ability to do anything other than make empty threats. That's all we have for you today. If you enjoyed this video, please press that like button, comment below, and let us know if you have ever had to deal with a debt collector and how you handled it. Please subscribe and stay tuned in the future as we will have more great videos highlighting other ways to help increase your wealth and attain financial freedom. As always, take care, and we'll see you next time.